I am going to turn it into the hands of Ms. Jocelyn Hartrick and Stacy St. Hubert for our November CLE.
Thank you, Teresa. Good afternoon, everyone. The concept of access to justice is near and dear to both Jocelyn and I because, unfortunately, real access to justice eludes the most vulnerable among us because of lack of understanding of the laws and the legal process, and quite frankly, just plain fear. These people either do nothing in response to a lawsuit or don't pursue legal remedies available to them. I don't know about you all, but the first time I appeared in court as an attorney, I was nervous. I was exposed to the justice system. I was educated, I passed the bar, I was prepared and ready to proceed, and I was still very nervous. Can you imagine being a pro se litigant that has never had any experience with the legal justice system, appearing to defend him or herself, or appearing to present a case to the court? They're very nervous. This leads me to the next issue that we should all consider and keep in mind as we proceed through this presentation. Appearing in court is one thing, and it carries a great deal of implications for the pro se litigant. However, the pro se litigant's ability to get his or her point across is another thing. To be heard, to be listened to is quite another thing. I'll go through briefly a roadmap of the presentation and some of the topics that we're planning to cover today. First, we'll talk about the pro se problem. We'll talk about access to justice. We'll talk about briefly some issues related to the pro se litigant in federal court. We'll touch on the bankruptcy court system, which is a part of the federal court system. And we'll also talk about the state court. We'll talk about ethical considerations that you should keep in mind when engaging with a pro se litigant. And finally, we'll talk about some practical considerations. Just a quick pointer, please take out your cell phones. This is an interactive presentation, and pretty soon you'll be asked to use them, so take them out and get them ready.
Okay. Thank you, Stacy, for that introduction. The question is, why is it called a pro se problem? So I want to explore some of the attitudes towards pro se litigants that attorneys have and discuss briefly the status of pro se litigation in Florida. You know, a pro se litigant is someone who represents themselves. And there's that popular saying that a lawyer who represents herself has a fool for a client. So the question is, what does that make a pro se litigant? Just food for thought. Okay, so why call it a problem? We are going to take a poll, a live poll, take out your cell phones. You can either text your answer to 650-600-9016, or you can open your web browser to m.smspoll.net. In the next 4 screens, we're going to go through 4 questions in 4 minutes. Let me know when you're there, look up. Each option will have a special code. You'll just enter the code into the website or text that code to that number, and your votes will come up. Are we ready? Okay. First question, what percentage of your practice involves pro se litigation? 10% or less, 10 to 25%, 25 to 50%, or 50% or more. No, it's not working. It's not working? Okay, we'll use a show of hands then. We're having technical difficulties, but by show of hands, 10% or less. Okay, so 10 to 25%, how many people have that much pro se litigation in their practice? No? 25 to 50%? One person? 50% or more? A couple of people, okay. So we have a lot of people involved in pro se litigation. Okay, how do you feel about having a pro se litigant as an opponent? Do you love it because it's a guaranteed win? Do you hate it because it's too frustrating to deal with pro se litigants? Are you neutral about it because litigating is hard either way, right? Let's be honest. And or is it all the above, depending on your mood? What would you say? Let's try this one. Can you try to text or enter it into the website and see if it works? Okay, we'll do show of hands then. How many people love it? Guaranteed win. One person. Okay. How many of you hate it because it's just way too frustrating? Yeah, that's the common attitude. It's very frustrating to deal with pro se litigants. Neutral about it, we have a few people. And I'm all of the above because I'm moody, so it depends on my mood. Okay. Next question. What is your biggest frustration when dealing with pro se litigants? There are many, but I've detailed 4 here. They don't know the rules of procedure. They know the rules, but they won't follow them. The judges give them too much leniency, or they don't understand the law, which is a little different than understanding the rules, right? Because the rules is about procedure, it's about evidence, but the law is about whether their facts entitle them to relief in court. So how about the first one? They don't know the rules of procedure. Is that your biggest gripe with them? Okay, one person. How about they know the rules, but they won't follow them? How many feel that way? Oh, no one. Okay.
One.
One person? Mm-hmm. Judges give them too much leniency. We have a couple of people. Okay, we're going to address that issue later. And they don't understand the law. Okay, most people in the room, right? Because they're trying to get relief, but they just don't quite know how to get there. So I'd like to thank you for your patience with our technical difficulties. And this is the last question. What do you think is the biggest influence on a lawyer's negative perception of pro se litigation? How many of you think it's traditional legal training? One person, couple people. Resistance to change, right? As lawyers, we're taught stare decisis. We do what we've always done unless there's a really good reason to do it differently. So we have a strong resistance to change. No one? Okay. Economic self-interest. That's a good one, right? Because pro se litigants take up a lot of our time, and we're unlikely to collect a lot of money from those cases. And overwhelmed from current workload. That's one of mine, right? I have so much work already. It's tough for me to deal with this additional burden. So I want you to consider some statistics. The Florida Bar Foundation did a project. They called it Everyone Counts Day. They had 35 attorneys view 190 cases involving 277 individuals. And what they found was in domestic violence cases, 88% of the litigants were pro se. In consumer and finance cases, 37% involved pro se litigants. And that was just one day in one court. So we point that out to you so that you understand that pro se litigation is going to affect all of us in some way. Okay? Stacy is going to talk about the different kind of pro se litigants that exist and the rise in pro se litigation that we anticipate.
In order to efficiently and effectively litigate your individual case and manage your caseload, you need to be able to identify the type of pro se litigant that you're dealing with. That's key because that's where you'll start from, that's how you build your strategy, that's how you'll be effective, that's how you'll manage your time efficiently. There are several types of pro se litigants that Jocelyn and I discussed. The first one is a savvy, sophisticated pro se defendant. They're lawyers. Lawyers can be pro se as well. They're executives, they're accountants, and they're someone or they're a person with previous experience with the legal system. So they're savvy and they're knowledgeable. They know enough to do well. Some of them just know enough to be dangerous. Serial filers. At one point or another, several of us have come across these type of individuals in our career. We see a lot of serial filers using the bankruptcy system. We see serial filers filing lawsuits against for various grievances against lawyers, judges, or both. Whenever something happens in a case that they're unhappy with, they decide to sue the lawyer and sue the judge. We also have sovereign citizens, very dangerous. They can be violent. They're seen in every type of practice, criminal, civil. They're commonly seen for me in collection cases. When I did collections, there are a lot of sovereign citizens. They file several long pleadings that are illogical, nonsensical, sometimes not even applicable, can't make heads or tails of it. You also have prisoners. They have the previous experience with the legal system. They have lots of time on their hands and lots of advisors around them. Then there's everyone else. They may not fit into one category. They may be traces of the other categories. These are the most common groups of people. A lot of them will not file anything in the case. It'll go to default. They'll file a basic answer admitting the allegations. We love those. We'll file a motion for summary judgment. They'll file letters, pleadings with defenses. As we have an increase in technology and availability of information on the internet, these people will tend to use that to navigate the legal system. Why is there an increase in pro se litigation? There are several things going on. The Legal Services Corporation is experiencing a decrease in legal funding. There's also a threat of total defunding. With IOTA, there's reduced funding for legal aid in Florida because there's a decrease in interest payments. There are lower account balances. Finally, we have resources such as AVVO on the internet, LegalZoom. I can do it by myself is now probably more a confident statement by a pro se litigant. Everyone can be a lawyer from home. There are also advances with technology in terms of e-filing. There's less screening by the clerk, hits the docket immediately, and also facilitates more ease in filing. So people are more comfortable with proceeding pro se because now they can just e-file things. Access to justice. Justice Thurgood Marshall said, "We recognized long ago the mere access to the courthouse doors does not by itself assure a proper functioning of the adversary process." Consider and keep in the back of your mind, is perceived access to justice justice at all? Some other statistics for you to keep in mind along with that heavy lifting that I just laid on you. 3 million Floridians live at or below the poverty line. 80,000 people were assisted in 2015 with legal services. 1.6 million pro bono hours were logged from 2015 to 2016. Pro se litigation is not going away. It's increasing, it's coming your way, and you need to be prepared.
Okay, so before we go into some of the technical things like the rules and the law and the practical tips that we want to offer you, I just want to take a moment to talk about unconscious bias. The Hillsborough County Bar Association just did a great bench bar conference discussing this, and it affects every area of our lives and careers, and it will also affect your interactions with pro se litigants. Pro se litigants want one thing, their day in court. That's going to look like a lot of different things. It's going to look like mediation. It's going to look like a hearing. It's going to look like a trial. It's going to look like a meeting in your office. But that's all they want. So if we can offer that to them, we can ease the entire process. But I want you to also keep in mind that someone's inability to pay for legal services or to hire an attorney is not necessarily a reflection of how serious they take the proceedings. I remember someone said to me once, well, if they really cared, they would have hired a lawyer, or they would have come up with the money. But some people can't. And whatever other biases you may have, just check them at the door when you're dealing with a pro se litigant. And we can't bring up the pro se problem without proposing a solution. So I propose these 4 things need to come together in order for us to properly facilitate pro se litigation. We need technology to play a role, and it has increasingly been playing a role because of access to information on the internet, access to e-filing, and also remote contact between pro se litigants and attorneys to help them out. We need funding, and if the government's not able or unwilling to fund, then as private attorneys we need to come together and figure out how we're going to increase the funding, because there's a business case to be made for it. When the courts are clogged with pro se litigation, they can't get to your case. When they're trying to figure out what this person filed for the 5th or the 6th or the 7th time, they can't get to your motion for summary judgment, they can't get to your motion to dismiss, they can't set your hearing. Private attorneys can also play a role, not just through funding, but also by following some of these tips we suggest here. And then the courts, of course, play a very large role. I have some of my colleagues here from the federal courthouse. We see pro se litigants filing all of the time. And right now, they're doing the heavy lifting. So we really need to step up in these other areas in order to help out. Okay? So I'm going to talk about federal court, some practical considerations. There are a couple of rules that apply specifically to pro se litigants in federal court. We have Middle District of Florida Local Rule 1.05E. that rule says that pro se litigants don't have to file the civil cover sheet. And some of you have seen that when you file, you have to check off, what kind of case is this, how many people are involved, etc. Now, that sounds like it's not a big deal. But when a case is filed and the clerk's office receives it, they use that information for statistical purposes and to assign the case to a judge or a division or to figure out what to do with it next. So if a pro se litigant doesn't have to do that, that means that clerk has to now read the 35-page thesis that this person filed to figure out what to do with it, right? So it starts to clog the docket a little bit. But there's a reason why they do that, right? Because as we're going to discuss later, pro se litigants are held to a less stringent standard than attorneys. The U.S. Supreme Court Rule 28.8 says you have to be a licensed barred attorney or admitted pro hoc vice in order to appear in Supreme Court. They used to allow pro se litigants to come to the court to argue, and there's some famous cases, but they no longer will allow that. So if someone's case gets to the Supreme Court, they must have an attorney representing them. Some pleading requirements for pro se litigants. The Supreme Court and the 11th Circuit both say liberal construction of the pleadings, and they're going to be held to a less stringent standard than those of a competent attorney. So that means that law clerks like myself, like Natalia, like Andrea, who are here, like Jeff, we have to read the pro se litigant's complaint or motion or letter or attachments, and we have to figure out what are they trying to say. And that also means, as private attorneys, you're going to have to figure out what they're trying to say so that you can assist the court in resolving that particular pleading. Federal Rule of Civil Procedure 11 says that pro se litigants do have to sign their pleadings, and they do have to stand behind the representations they make to the court, just like attorneys do. And then there's also a statute, 28 U.S.C. Section 1651A. It's the All Writs Act. And the courts in the 11th Circuit and other circuits have used that statute and other case law to control abusive litigation. So when you have vexatious litigants, people who keep filing cases over and over and over again against the same people making the same claims, there is an avenue for the court to try to control that. So if you ever have that issue come up in one of your cases, keep that in mind. Motion the court to address it, or possibly use that as a mechanism to control the pro se litigant's actions. So I just want to give you a few from the federal court bench. Like I mentioned earlier, the burden very much is on the court right now with dealing with pro se litigants. And Magistrate Judge Mix said this in an article she recently published. The time and energy spent by the court are making sure that every pro se litigant has every reasonable opportunity and tool to stay afloat in the variable seas of federal court litigation is truly staggering. That is how intense it is for the courts to deal with pro se litigants. So if you have pro se litigant involved in your federal case, there are some resources you can point them to. And yes, I suggest you point this pro se litigant to these resources, because it will only help you if there's a knowledgeable person on the other side who can help assist the pro se litigant so that the case can go more smoothly. Okay?
We're just going to touch a little bit on bankruptcy. Rule 11 of the Federal Rule of Procedures is also present for bankruptcy through Rule 9011. These rules, which is bankruptcy's form of Rule 11, it fully applies to pro se litigants. It applies to all written filings, the petition, motions, or papers filed. It also applies to any arguments made to the court. For the purpose of this presentation, I will focus on the creditor's lawyer and the pro se debtor. As we mentioned earlier in the presentation, the first thing that you need to do is identify your type of pro se debtor and her objective. Is it a delay? Is your pro se debtor a serial filer? Are they filing multiple bankruptcies to delay your state court matter? How savvy is your debtor? Is it someone that you should file a motion for sanctions on? Or is it someone that simply does not understand the bankruptcy process? Is it a situation where the person simply is trying to reorganize and has no interest in your client's property? Should you file a motion for relief? Should you consider mediation? Is this someone that you just need to come to the table with and have a conversation and try to work it out? Each solution, be it mediation, be it sanctions, should be to meet your client's objective. Also, another pointer, you can identify some of these things that I mentioned, be it the debtor's objective, by reviewing the schedules, reviewing the debtor's plan. Determine how your client is being treated in the bankruptcy. Look at the debtor's previous filing patterns. Is it constantly a situation where the debtor is filing a Chapter 7 every time a sale date comes up? You need to evaluate those things to determine your strategy in the bankruptcy as a creditor's rights lawyer. Also, just to keep in mind, when reviewing bankruptcy petitions or schedules, check for glaring inaccuracies. Check for inaccuracies in the schedules. Review the plan, review the motion. Try to figure out, is this something intentional or is it someone that simply does not understand the bankruptcy process? If it's someone, which is the bulk of it, is it someone that does not understand the bankruptcy process? As Jocelyn mentioned, it's in your best interest. Bankruptcy is very complicated. You need to point them in the right direction. There are several resources available to pro se litigants in bankruptcy. Several of them are listed here, and we'll make the presentation available to you. The bankruptcy court has a legal assistance program. There's a lot of information online that you can go through. There's even a video on the Middle District's website that's included in both Spanish and Creole for pro se litigants. Next, we'll go into the state court considerations. The Florida Constitution guarantees access to courts. I'd just like to take a moment to read a quote from a second DCA case that I have here. It's a 1993 case, 619 Southern 2nd, 1029, decided in June 1993. The court said, "Our power and desire to impose sanctions against pro se and or indigent litigants is limited by the constitutional right of access to the courts, by the statutory ability of indigents to obtain court services at little or no cost, and by a well-recognized principle that non-lawyer litigants not be penalized for any inability to observe strict compliance with rules or of procedure. None of these considerations, however, should inhibit a court from stepping in to prevent abusive nuisance and litigation." So there is there's a difference between lack of understanding and abusive process. You need to be able to identify that and handle your litigation accordingly. And there are tools available to you, and I'll mention some of those tools to you. While the court goes on to say, while pro se litigants may be given a certain amount of latitude in their proceedings, they may not in such a fashion as to abuse the judicial process, prejudicing the opposing party's interest as well as other litigants' access to the judicial system. With that in mind, and as a backdrop, I've included on the PowerPoint some rules that you should consider. 57105 applies to pro se litigants. If you're dealing with an abusive pro se litigant, use 57105. Also, keep in mind, though, your pro se litigant that's a lawyer is entitled to their fees. So you need to be careful as well when dealing with pro se litigants in terms of, you should always be mindful of the rules, but just a pointer that they're entitled to their fees. Another law that I came across that you want to keep in mind if you're dealing with someone like a sovereign citizen or a serial filer, someone that's being abusive that understands exactly what they're doing, is called the Florida Vexatious Litigation Law. It's Florida Statute 68.093. Some helpful pointers for me as a young collections attorney had to do with corporations when you're dealing with a case that's not small claims. While individuals have a right to represent themselves in court, corporations are artificial entities that appear through an agent, and they must be represented in court by an attorney. So if you have a business that you're suing or that's suing you, and it's not a small claims matter and an attorney is not the person filing the pleadings, it would be a good idea to bring that to the court's attention, file a motion to strike, try to have that addressed earlier on. Those cases are usually more complicated and really should have an attorney on the other side. Next, important reminder, service. Always protect your judgment and your time in court. Proper service and notice is super important. If you can do anything by email, go ahead and do that. We now have the ability to serve pro se litigants by email. If they provide you with that information and request service by email, I highly recommend that you go ahead and do that. People move, but you have an email, you should try to defer to that process to help ease your litigation and notice issues as you proceed in litigation. We have a quote here. We conclude that it is a mistake to hold a pro se litigant to a lesser standard than a reasonably competent attorney. We understand that, but we know in reality and for practical purposes, that's not what's going to happen. Be patient. Keep in mind some of the things that I talked to you about in my introduction. These people sometimes are just nervous. It's not intentional. We have rules to deal with people once we identify that they're abusing the process. Be patient, listen, protect your judgment, and give them a chance. Another quote here, just briefly review it. A judge's worst nightmare is having a pro se litigant appear in front of him or her. The judge is in an adversarial system and has to balance the rights of both sides. When a person comes in without an attorney representing them and the other side has an attorney, what is the judge to do? Also, I wanted to share with you some resources for pro se litigants for the reasons we've discussed before. There are several websites here. If it's a matter of lack of understanding and you think it might be helpful, go ahead and share this information. Get them on the right track. We're here to present our case and win on the merits. There's nothing wrong with leveling the field and providing the rules.
Okay, we're going to briefly talk about the ethical considerations. Now, I know we're talking a lot about rules and access to justice. We're going to get to the practical part, I promise. But just before that, a couple of things to keep in mind in terms of ethics. ABA model rules tell us we cannot give advice to, legal advice to pro se litigants, right? The only thing you should be telling them is you need to get an attorney. Just repeat that over and over. It is shocking how many pro se litigants will come to you as the lawyer suing them, asking you for advice, or taking something you say as bond, like that's it. Oh, that's what the law says? Okay, so no, that's what I say the law says. For my client, you need to get your own attorney to help you figure out what's going to work for you. So as long as you keep that at the forefront when interacting with pro se litigants, you should be good. Four other things in the model rules to keep in mind. No representation that involves concurrent conflict. You must disclose legal authority that's adverse to your client. So if you're dealing with a pro se, you still have to do that. You have to comply with obligations of the rules of court and no ex parte communications, which we know. But a lot of times we know judges, don't we? We go into the courtroom and we're chatting with the judge, and we just saw the judge at an event, and the pro se litigant comes in and sees us chatting with the judge. Now, what do you think their impression is in that moment? That they're not going to get a fair shot. So if you're dealing with a pro se litigant, just be as formal as possible, even if you know the judge, or maybe wait till the hearing is over to chat with the judge, but stay as formal as possible when a pro se litigant is involved. And the rules regulating the Florida Bar has a specific rule on unrepresented persons. The first thing is limited representation. So this has probably happened to you because it happened to me a lot. I'm dealing with a pro se litigant and they keep saying, my lawyer said this and my lawyer said that. I said, well, I don't see a notice of appearance. Who's your lawyer? Well, it's just someone I'm talking to. Okay. So you need to understand if this person is going to appear in the case. Because if they appear in the case, then you can't speak to the pro se litigant directly. But if they don't appear in the case, then you can. So what I like to do is say, what is the name of your lawyer? I will give him or her a call, and we'll see if they're going to appear in your case. That needs to be clear up front. Because you don't want to go to a mediation or enter a settlement agreement or go to a hearing and later find out that this person was represented. Now you have a bar complaint and your settlement or your judgment might be in jeopardy. The other point is the same as I mentioned before. You have to let the pro se litigant know you do not represent them. And if in any way they think you're a disinterested party and that what you're saying is kind of education for them that they can use, you have to eliminate that perception right away. All right, now we're going to go into some of the practice pointers, and Stacy's going to take over.
Let's start with motion practice. You'll hear me say this over and over again when dealing with pro se litigants. Is your service good? If you're prosecuting the case, if you're the plaintiff, Review your return of service. If you're setting a hearing, where did you send your, before any hearing, when you're prepping for your hearing, hopefully not the morning of the hearing, you check your notice of hearing to make sure it was sent to the correct address. You don't want to have to do a do-over. You don't want to have to cancel the hearing right on the eve of the hearing and upset your judge. Make sure that your notice is good. Another helpful pointer when dealing with pro se litigants, again, they don't know the rules, they don't know the system, they'll write letters. They'll mail them to your office. Do a notice of filing. Protect your record. Make everything transparent. Ensure that it's in the court file. Don't just ensure that it's in the court file. If you're doing a motion for summary judgment, your notice was good, your service was good, you're at your hearing, let the judge know about this letter. Talk about what the letter says. Every motion for summary judgment hearing, if there is a letter or answer, I go through it with the judge. I protect my record. I address any affirmative defenses. They may not be eloquent, they may not be spelled out correctly, but there is an affirmative defense in there. We're trained on that. We can spot it, address it. Protect your record. I don't want to have to come back. Get it out of the way. Address all those things with the court. That leads me to the next point. Everything they send to you, don't disregard it. Even the sovereign citizen multi-page document, review it, read it, spot the issues, put the issues before the court, address them. Motion for summary judgment is a wonderful thing. You might be able to get your judgment. File your motions to strike. File your motion to summary judgment and get to hearing. Motion for judgment on the pleading is another wonderful tool. Use it. Motions to dismiss with prejudice. If there's no plausible cause of action, file them. Mediation, wonderful thing. It's a great opportunity to get a great result for your client. Use it. Narrow the issues in mediation. Be respectful. Listen. Remember that group of everyone else. Remember what that experience might be. Be respectful, address the issues. A side note for handling discovery issues, very frustrating. I understand sometime with pro se litigants. If you're receiving too many requests, use your motion for protective order. Respond to their discovery, don't disregard it. If you're not getting responses, use your motion to compel, get your court orders, protect your court file. Again, hearings, be strategic. For example, with your sophisticated pro se defendant filing multiple motions and discovery, I had this happen to me. I had a very sophisticated pro se defendant, made my simple case more complicated than it needed to be, kept tying me up in discovery, kept every time a trial was set filing a motion to continue. You know what I did? I requested a case management conference, laid my cards on the table, went through the record with the judge, and asked for strict timelines along with a trial date. All of us were held to those dates. I got my trial, I got my judgment. That's what you need to do. You need to control your case, be fair, be upfront, be transparent. Don't underestimate pro se defendants. Don't do it. They're intelligent people, they're smart, they read. Be patient, as I mentioned. I can't stress that enough. It's super frustrating. Be patient. Listen. Know when to stop talking. That leads me to trial. Again, just keep in mind this is your last chance to settle. I did a lot of replevant actions with mobile homes, and for whatever reason, I discovered more time than not, these people just wanted more time. They didn't want to fight with me. They just needed 60 days, 120 days to get out. Get the settlement authority from your client. Go to trial with that last-ditch effort in your pocket to resolve. Never go to trial without a last-ditch settlement offer. You might get rid of it without a trial. Again, proper notice for your trial. Protect the record. Get all your exhibits in. Don't get lazy because it's a pro se defendant. Pretend you're up against the best lawyer you know. Protect your record. Get all your exhibits in. Prove your case. Even if they're not saying anything, protect your record. Know when to stop talking. When that pro se defendant is talking, know when to stop talking because they might prove your case for you. So all of these things, appear for your hearings, respond to pleadings, file pro se pleadings, use hearings strategically, stay calm. All of these things will make the judge's job easier and will help your case to go smoothly. It goes without saying, be clear, be concise, and be professional. Next, we have a category of people that are vulnerable or vulnerable pro se litigants, such as the elderly, the disabled, the mentally or developmentally challenged, non-English speakers. Use sensitivity in all dealings. Allocate additional time for your hearings and meetings and responses. Don't rush to the gate. As I said, protect your record. Attempt settlement early if possible, and anticipate additional leeway from the court. We know it's going to happen. Be prepared for it. On the other hand, we have belligerent pro se litigants. History of violent behavior or aggressive communications. You can tell in the pleadings they yell at you during hearings. Notify court staff and security before your hearing so that they're aware of what you're up against. Come early. Try not to run into them on the elevator, and avoid being alone with them and leave late. Schedule mediations at the courthouse or at your law firm. Stay calm and do not engage in physical contact. That's very important. You don't know, there's no reason, there's no case that important.
Yes. Thank you, Stacy. I want to emphasize one additional point. We have to speak the pro se litigant's language. Here's why. Il est important de parler en anglais clair lorsque vous communiquez avec des non-juristes. Right? Okay, let me try it again. Es importante hablar inglés plano cuando comunicas con personas que no son abogados. A couple of you got that one, right? Oh, okay. It is important to speak in plain English when you communicate with non-lawyers. Make sense?
Yes.
Okay. So let's try that in legalese. So I have something written here. I got it out of a case. The doctrine of res judicata, can't read it, bars the plaintiff's claim because there is a final judgment on the merits. The decision was rendered by a court of competent jurisdiction. The parties, or those in privity with them, are identical, and the same cause of action is involved in both cases. Accordingly, the court must dismiss the case with prejudice. Sounds fancy, doesn't it? Smart. What does it mean to a pro se litigant?
Gobbledygosh.
Nothing, right? Now I want you to think about how would you put that in plain English. And while you think about that, I want to point out, you know, the last slide, when I said the line in French, you kind of looked at me like, we don't know what's going on. Is she okay, right? What's happening? I'm confused. It's a little disorienting. Then I said it in Spanish, and a couple people understood, and I pointed out that a couple people understood, and some of you might have felt a little left out, right? So that's how a pro se litigant feels when we speak in legalese. So I'm going to offer a translation. It's not a perfect translation, y'all. I know we're all smart and we can, be very critical, but the point is to convey the message to the pro se litigant. So here's my plain English version. When a plaintiff files a case in court and the judge reviews and dismisses the case because the law does not support the claims, the plaintiff cannot then file a new lawsuit against the same people making the same claims. The law says the court has to dismiss the lawsuit. Does that make sense? Mm-hmm. Can a pro se litigant understand that? Not only can they understand it, now they feel comfortable responding to it. And if they can respond to it, they feel like they've participated in the process. Does that make sense? And just one quick tip. We want to let the court know that we understand the standard, right? But we also want to communicate to the pro se litigant. So this is what you do. You use the plain English in your introduction. Use the legalese in your legal standard in the middle of the motion. Then you use the plain English in your conclusion. The pro se litigant is only going to read the introduction and conclusion anyway, right? So now everybody's covered and everybody understands what's going on. Fair enough? Great. Language matters because whoever controls the words controls the conversation. Whoever controls the conversation controls its outcome. Whoever frames the debate has already won it. So when pro se litigants come into court and the judge and the lawyer is speaking the same language, they feel like they've already lost. So we have to really make an effort to let the pro se litigant participate in the conversation by speaking in plain English. All right, now we get to the best part of the presentation. Movie time. We have some goodies for you guys that we brought in since it's movie time. Some popcorn, some Snickers, so if you feel salty or sweet, you go with it. Okay, we all know Hollywood and TV loves to portray lawyers in a bad light. They just love to make us look bad, don't they? So we have some great examples of things we should be careful of and to try not to do when we're in court. So the first practical communication with written and oral communication is to be clear, concise, and professional. Imagine that your communication will be read aloud in court.
Read policy 784-99-09886. Dear Mrs. Black, on 7 prior occasions, this company has denied your claim denied. We now deny for the 8th and final time. You must be stupid. Sincerely, Herbert Lumpkin, Vice President.
Now, as dramatic as that is, that actually happened to me in court. I was a brand new attorney. I was training with my co-counsel, pro se litigant on the other side, and she pulls out this letter and says, "Judge, you won't believe what they told me." And she starts to read the letter. And unfortunately, the letter was actually written to her attorney, but her attorney had since withdrawn. So the tone of the letter was just really bad. And she's reading it, and the judge's face is just turning red. And his eyebrows, Judge Jeske, y'all know Judge Jeske? That eyebrow went all the way to the ceiling, okay? So we won the case, but we lost some respect. Just please be careful. If you get frustrated with the pro se litigant and you're writing communication, I recommend either having a colleague read it for the tone or wait 24 hours before you send it, just to make sure the tone is just right, okay? The next tip. Some pro se litigants are well versed in the law despite limited education, casual appearance, or poor writing skills, especially when they're at oral argument. So let's see what happens here.
In light of Mr. Shelton's economic means and his potential flight risk, the egregious nature of both Mr. Ames and Mr. Darby's deaths, the state requests that bail be denied, Your Honor.
Seeing as how you've waived your right to counsel, Mr. Shelton, do you have anything to say, Mr. Shelton? Do you have anything that you'd like to say, Mr.
Yes, Your Honor. Should I stand?
Please.
Your Honor, I'm a law-abiding citizen. I'm just a regular guy. I am not a flight risk. This is my first alleged offense. And the prosecution has not presented one single piece of evidence against me. Now, in these circumstances, unless the state has obtained some new piece of information relating to my involvement in the matter in question, then I find it highly prejudicial, even constitutionally offensive, to keep me detained without bail. It's a slippery slope, Your Honor. Haven't we seen the result of such violations both internationally and domestically? Case in point would be Dave v. McDonough, docket number 04155.
I am actually inclined to agree with you, Mr. Shelton.
Your Honor, Mr. Shelton has agreed to give us a full confession.
Has he given it, Mr. Rice?
No, Your Honor.
Well, then, in my opinion, the state has failed to establish a compelling basis for its motion, and I will grant bail in the amount
Your
of...
Honor, I will caution you not to do that.
He would caution Your Honor not to do that, okay. This happened to me too, but I was prepared. I had a pro se litigant, the Homeowners Association foreclosed on his home, and he was very upset about it. So the man took an axe to his house, drywall, toilets, bathtub. I mean, the house was absolutely destroyed. He left. Several months later, he tried to come back into the home. So the Homeowners Association asked me, we need to stop this. So I filed an emergency motion for preliminary injunction. I have all the pictures in there. I have all the eyewitness statements. And the gentleman shows up, and he's well-dressed, poised, and well-spoken. But if I did not have those pictures and the eyewitness statements ready, the judge would have had a very hard time understanding how this person did what we accused him of doing. So you just gotta be prepared. Just like Stacy said, prepare like you're preparing against an attorney, because you never know who's gonna show up. Here's another one. Don't try to get over on pro se litigants, and don't let them get under your skin. Just because someone's a pro se litigant and you can kind of get away with a couple of things, resist the temptation, because it will catch up with you. You want to get a good result quickly. Let's see what happens here.
I'm not judging you, Willie. No. Anyone coming from what you came from, then paying their way through East Oakley College and Thompson Law by writing papers for Princeton kids on the internet. My God, $60,000 in debt and 97% conviction rate. Wow. You deserve it, kiddo.
What have you been doing?
Oh, I'm permitted the use of a private investigator.
Not to investigate me,
Why not? You're investigating me.
because you shot your wife.
Allegedly. That's how it works, right? If I can't introduce something in court as evidence, it doesn't exist legally.
I'm not gonna play games with you.
I'm afraid you have to hold a sport.
What is this? What is it? Some kind of form of communication?
Uh-huh. You sent me a box of papers.
It's called discovery. All right. That's where the state is legally obligated to provide all the evidence to the defendant, so you can prepare your defense.
There's nothing in it, Willie. You haven't actually discovered anything.
That's one point of view. Another might be that I've hit the mother load.
What if they found the gun?
I don't need the gun to convict you.
Let's see if he needs the gun to convict him, shall we?
I'm not further evidence this time around.
Jury is pleased with our apologies. The defendant is free to go.
Thank you. The room talk is we meet twice a day.
You saw that judge's face? She couldn't even say judgment of acquittal. This happened to me too, by the way. So I lost to a pro se litigant on a technicality, and it's usually a technicality that they get us on. And the judge was very pained to dismiss the case, but you know, the service was bad. Like Stacy said, make sure that service is good. This is a very humbling experience. I hope you never have to go through it, but every now and then a pro se litigant is going to win. Oops. Okay, this is the last tip. If the pro se litigant is acting a fool, y'all know what I'm talking about. Being ridiculous, getting loud, saying all kinds of things, calling you names. The court is going to recognize it for what it is. Let the court handle it. You can object once as a matter of course, just to kind of protect your record, but just, you know, sit back and enjoy the show.
Day number 1218, Philip Banks versus Will Smith and Carlton Banks for non-payment of rent.
Philip, I can't believe you're suing your own son and nephew.
Oh, relax, Lois. This is just a little lesson in responsibility. They're probably not even going to show up. In fact, they're probably home right now preparing their apologies.
Looks like they've prepared more than an apology. Mr. Banks, your opening statement.
I don't have an opening statement.
Mr. Smith?
Thank you. Your Honor, I'm from West Philadelphia, born and raised. That's where I spend most of my days. I don't have a big bag of fancy courtroom tricks or a high-priced degree from Princeton, like my worthy adversary, Judge Philip Banks. But what I do have is the truth. Oh, shut up! Your Honor, Mr. Smith is making a mockery of the entire legal system. And this man is making a mockery of a finely cut Italian suit.
Questions? Yes, Barbara.
And this is a true story. I had this case, we just concluded it. It was a divorce. I'm representing the wife, the other side is pro se. So of course, he's filing all these pleadings, and in one of his pleadings, he alleged that my client had committed Medicaid fraud when she placed their child on the state's healthcare system. So of course, I filed a request for discovery asking for documentation. So he sends to me eventually, 2 days after he gets it, which this is a recent, some copies of some documents from the state of Florida with, the letter to my client where we investigate. So I'm objecting. And so I'm objecting this. His response in court was, Ms. Pittman told me to do this. And of course I'm shocked. And the judge said, you said Ms. Pittman told you to do this? Yes, Judge, she filed this discovery request asking for this. So I interpret that to mean Ms. Pittman told me to go down and file a fraud claim against her client. What? Yes. Of course, I'm stunned. I don't know what to say, okay, at this point. So eventually, we end up working out and we end up resolving the case. But that bothered me for a period of time, that I could file a discovery request asking for this discovery, and he interprets it. My client, of course, was a friend, so I was able to smooth it over with her. But just think if it was somebody that didn't know, that would have took him literally when he said that I told him to go down and file a fraud claim against my client.
And what was important with that is it was in writing.
It was in writing.
So you go to the court and you say, Judge, here's a discovery request.
Yes, it was a
So
discovery
that's
request.
his interpretation.
That was
That's
his
not what actually
interpretation,
happened.
right,
So thank
right.
you for sharing that, Barbara.
Right. But it was a little unnerving. And I'm never at a loss for words, but that one temporarily threw me.
Any other questions? All right, that concludes our presentation. Thank you so much.
Thank you.